The concrete dust was still settling when I pulled up to the gate. Where my stables had stood for 18 years, there was nothing but yellow caution tape and a demolition crew packing up their equipment. I stood there with my truck engine ticking in the September heat, watching a man in a hard hat load a jackhammer onto a flatbed, and I understood with perfect clarity that Katherine Holling had just made the worst mistake of her life. She didn't know about the easement. Nobody had told her, and I had spent 3 weeks making absolutely certain of that. Let me take you back to where this started. 3 months earlier, on a Tuesday morning that began like any other, I was mucking out the stalls when I heard the golf cart. I knew the sound by then. Katherine's cart had an electric wind that carried across the property line like a dentist's drill. She pulled up to the fence wearing white linen and sunglasses that probably cost more than my truck payment. "Mr. Garrett," she said, not getting out. "We need to discuss your horses." I leaned on my pitchfork and waited. The HOA has received multiple complaints about the noise. The whinnying, the stomping, the general barnyard atmosphere. It's affecting property values in Meadowbrook Estates. Meadowbrook Estates, the gated community that had sprouted up 3 years ago on what used to be the Hendricks farm. 40 McMansions on quarter-acre lots, every one of them beige or gray. Every lawn maintained by the same contracted crew. My property, 12 acres, family-owned since 1947, sat on the southern boundary. We'd been here when this was all cattle land and state forest. My grandfather had run a small boarding operation. My father had expanded it. I kept 6 horses now, 3 of mine and 3 I boarded for families who'd been with me for over a decade. "Katherine," I said evenly, "my property isn't part of your HOA. Never has been." She smiled the way a person smiles when they're holding a card they think you haven't seen. "The county noise ordinance doesn't require HOA membership, Mr. Garrett. It applies to all properties in the township. Agricultural operations within 500 feet of residential zones are subject to nuisance abatement procedures." She'd rehearsed that. I could hear it in the cadence. "I'm giving you 30 days notice," she continued. "Reduce your animal count to 0 or relocate your structures at least 200 feet from our property line. If you don't comply, the HOA will file a formal complaint with the county." "Katherine, it's Mrs. Holling in official context, please." I set the pitchfork against the fence post and walked closer. "You file that complaint, and we're both going to end up in a conversation neither of us wants to have." "Is that a threat?" "It's a fact. You should pull the original survey plats before you do anything else. I've reviewed all necessary documentation with our attorney." "Good day, Mr. Garrett." She reversed the golf cart and drove back through the gap in the hedge that separated our properties, the gap that used to be part of the old county bridle path before the development went in. I stood there for a while after she left. Then I went inside, opened the fireproof cabinet in my office, and pulled out the folder labeled Easements and Covenants, 1952. My grandfather had been a quiet man, but he'd understood land law. When the county had paved the main roads in the 1950s and rerouted traffic, he'd negotiated an easement to keep the old bridle path open. It ran from my property through what was now Meadowbrook Estates and connected to the State Forest Preserve on the far side. The easement was perpetual. It was recorded, and according to the survey map I was looking at, it cut directly through the footprint of Katherine Holling's backyard, right under the infinity pool she'd had installed last summer. I called Tom Driscoll, the land attorney my family had used for 40 years. He was semi-retired now, but still kept his bar certification active for cases that interested him. This one, I suspected, would interest him very much. "Tom," I said when he picked up, "I need you to pull a recorded easement from 1952 and check it against a current subdivision plat. And I need you to do it quietly." "How quietly?" "Quietly enough that nobody on the other side knows we're looking until I decide it's time for them to know." There was a pause. Then Tom said, "I'll call you back in 2 hours." He called back in 90 minutes. His voice had the tone of a man who's just found a $20 bill in an old coat pocket. "Marcus," he said, "do you know what runs under Katherine Holling's pool?" "A perpetual recreational easement granted to the Garrett family in 1952, maintained by right-of-way provision, never vacated, still on the county books." "You knew?" "I suspected. My grandfather used to ride that path every Sunday. I wanted to make sure before I said anything." "She's got no idea, does she?" "Not yet." Tom was quiet for a moment. "What do you want to do?" I looked out the window at the stables. At the horses grazing in the afternoon sun. At the land my family had worked and lived on for 77 years. Let her file the complaint, I said. Let's see how far she takes it. The formal complaint arrived by certified mail 3 weeks later. Katherine hadn't waited the full 30 days. The document was 12 pages long, notarized, and co-signed by 6 other Meadowbrook Estates residents. It cited County Noise Ordinance Section 14-7B, agricultural nuisance provisions, and included a log of alleged disturbances. Horses whinnying at dawn, trailer traffic on weekend mornings, flies, dust, and olfactory concerns. That last phrase made me smile despite myself. The complaint requested an immediate inspection by County Animal Control and Environmental Health, a formal hearing before the zoning board, and if I didn't voluntarily relocate the horses within 60 days, an injunction authorizing the county to do it for me. Tom read it over the phone, and I could hear him flipping pages. She went nuclear. This isn't a negotiation. She's trying to shut you down completely. Can she? Legally. Not if you're in compliance, which you are. I've seen your permits, your waste management plan, your vet records. You run a cleaner operation than most commercial stables. But the process itself is the punishment, Marcus. Even if you win, you're looking at 6 months of hearings, inspections, legal fees. She's betting you'll fold before it gets that far. I'm not folding. I know. That's why I've already drafted the countermotion. What countermotion? The one where we inform the county, and Mrs. Holling, that any action restricting your use of the stables interferes with your legal access to a recorded easement. Once we file that, the zoning hearing becomes a property rights case. Different ballgame. When do we file? Not yet. Let her think she's winning. Let the county schedule the hearing. Let her spend money on her attorney and gather her neighbors for the testimony. Then, 2 days before the hearing, we file. And we CC every party on record. I thought about that. About Katherine mobilizing her neighborhood, standing in front of the zoning board, presenting her case with the confidence of someone who believes the system is on her side. You're enjoying this, I said. I'm 73 years old, Marcus. I've spent 50 years watching developers bulldoze family land, and HOAs squeeze out people who were here first. If I get to watch one of them step on a legal landmine they built themselves? Yes, I'm enjoying it very much. The county inspection happened on a Thursday. A young woman from Environmental Health walked the property with a clipboard, checked the manure pile, the water troughs, the fence lines. She was polite, thorough, and clearly uncomfortable with the fact that she'd been sent here at all. Mr. Garrett, she said as she finished her notes, I'm required to complete this report, but I'll tell you off the record, you're going to pass. You're cleaner than half the licensed facilities I inspect. Someone's wasting the county's time. Appreciate you saying so. She handed me a carbon copy of her checklist. Every box was marked satisfactory. The hearing was set for October 14th. Katherine spent the 2 weeks before it organizing. I know this because I started seeing the signs. Cars parked along the Meadowbrook Estates main road for what the community Facebook page called informational meetings, a new post on the neighborhood forum titled Protecting Our Investment, and, most tellingly, a petition that went door to door. Eleanor Pruitt, who lived 2 streets into the development but had boarded her daughter's horse with me for 6 years, called me on a Sunday night. Marcus, I didn't sign it, but I thought you should know. Katherine's got 43 signatures. She's telling people your stables are a health hazard and that you've been cited by the county. I haven't been cited. I passed inspection. I know that, but she's not telling them that part. On October 12th, 2 days before the hearing, Tom filed the countermotion. He emailed me a copy at 8:47 in the morning with a subject line that said simply, sent. The motion was 8 pages. It cited the 1952 easement by book and page number, attached the original recorded survey map, referenced my grandfather's name as the original grantee, and requested that the court take judicial notice of the easement's existence before proceeding with any zoning decision that might restrict access to it. Then it got specific. The easement ran east to west across what was now Meadowbrook Estates, entering the development at the northwest corner of Lot 14 and exiting at the southeast corner of Lot 22. Lot 18 was Katherine Holling's property. The easement crossed her backyard at a width of 12 feet, passing directly beneath her pool deck, and the decorative stone wall she'd built along the rear property line. The final paragraph was a single sentence. Any structure built within the easement corridor without the express written consent of the easement holder is subject to removal at the property owner's expense under State Land Use Statute 47-09. Tom CC'd the County Zoning Board, Katherine's attorney, and Katherine herself. I was in the barn when my phone rang. Unknown number. I let it go to voicemail. Then I checked the message. Katherine's voice was tight and high. Mr. Garrett, I've just received a very concerning document from your attorney. I need to speak with you immediately. This is a misunderstanding, and I'm sure we can resolve it without. The message cut off. She called back 4 times that afternoon. I didn't answer. At 6 p.m., her attorney called Tom. Tom called me. She wants to settle. I'm sure she does. Marcus, she's offering to withdraw the complaint entirely. No hearing, no restrictions, and she'll personally apologize to you in writing. I looked out at the stables, at the horses in the pasture, tails swishing in the October light. What about the pool? I asked. Tom paused. What about it? Tell her I want it gone. The hearing happened anyway. Katherine's attorney tried to withdraw the complaint the morning of October 14th, but the county administrator ruled that once the motion was filed and public notice given, the proceeding had to continue. Too many parties were on record now. It had become a matter of county interest. The zoning boardroom was packed. Katherine sat in the front row with her attorney, a man in a charcoal suit who looked like he'd aged 5 years and 2 days. Behind them, I counted 23 Meadowbrook Estates residents. On my side of the room, Tom, Eleanor Pruitt, and 2 other families who boarded with me. The board chair, a retired county engineer named Bill Kowalski, called the session to order and summarized the complaint. Then he asked Tom if the respondent wished to make a statement. Tom stood, placed the original 1952 survey map on the overhead projector, and said, Mr. Chair, before we discuss noise ordinances, I'd like to direct the board's attention to a recorded easement that predates the complainant's subdivision by 65 years. He walked them through it, slowly, methodically, with the calm precision of a man who knows he's holding an unbeatable hand. The easement's origin, its purpose, its exact route, the fact that it had never been vacated, never been abandoned, and remained fully enforceable under current law. Then he placed a second map on the projector, the Meadowbrook Estates plat, with Lot 18 highlighted in yellow. He overlaid the 2 maps. The easement corridor cut across Katherine's backyard like a chalk line. The respondent, Tom said, is the legal holder of this easement. Any restriction on his use of the stables restricts his access to that easement. And any structure built within the easement corridor without his written consent is, under state law, subject to removal. Bill Kowalski leaned forward and studied the overlay. Mrs. Holling, he said, were you aware of this easement when you purchased the property? Katherine's attorney answered for her. My client was not provided with an easement disclosure at the time of purchase. The developer, the easement is recorded, Tom said. It's been on the county books since 1952. Any title search would have flagged it. Kowalski looked at Katherine. Did you conduct a title search, Mrs. Holling? She didn't answer. Kowalski turned to the rest of the board. They conferred quietly for 2 minutes. Then he turned back to the room. The complaint is dismissed. The respondent's operation is in full compliance with county standards. This board has no authority to restrict access to a recorded easement. Mrs. Holling, you'll need to address the structural encroachment separately with Mr. Garrett and your own legal counsel. This hearing is adjourned. The room emptied slowly. Katherine walked past me without looking in my direction. Her attorney stopped, extended his hand, and said quietly, That was well played, Mr. Garrett. I shook his hand and said nothing. Outside, Tom stood by his car with his arms crossed, watching the Meadowbrook Estates residents disperse. You know she's not going to take the pole out voluntarily. I know. You're going to have to enforce the easement. That means either she removes the encroachment, or you file for a court order to do it for you. How long does that take? 6 months, maybe longer. And it won't be cheap. I looked across the property line, toward the hedge gap and the roof of Katherine's house, just visible beyond it. I don't need the pole gone tomorrow, Tom. I just need her to know that I can make it happen whenever I choose to. Tom smiled. You're not going to file, are you? Not unless she gives me a reason to. 2 weeks later, I received a certified letter from Katherine Holling. It was 1 page, typed on personal stationery. She withdrew all prior complaints. She acknowledged the easement. She apologized for the inconvenience. And she requested, politely, formally, that I grant her written permission to maintain the existing structures on Lot 18 in their current locations, with the understanding that the easement right-of-way would remain unobstructed and that any future land use disputes would be resolved through direct communication rather than legal action. I read it twice. Then I called Tom. She's offering a truce, I said. She's offering you permanent leverage. If you sign that, she's on record acknowledging your easement rights. She'll never be able to challenge your stables again without risking her entire backyard. And if I don't sign, she lives under a sword for the rest of her time in that house, every day wondering when you'll enforce the easement and whether her pool is going to be the price she pays for it. I thought about my grandfather, about the bridle path he'd ridden every Sunday, the land he'd protected, the quiet way he'd handled people who thought volume was the same as authority. Send her a response, I said. Tell her I'll grant the permission on 3 conditions. 1. She personally delivers a written apology to Eleanor Pruitt for pressuring her to sign the petition. 2. She resigns as HOA president. 3. She never files another complaint about my property as long as she lives in Meadowbrook Estates. Tom laughed. Marcus, that's non-negotiable. He paused. All right, I'll draft it. Katherine signed the agreement on November 3rd. She resigned from the HOA board the same week. Eleanor got her apology, handwritten, delivered in person. And the stables, the ones Katherine had been so certain she could shut down, are still here, exactly where they've always been. I see Katherine sometimes, in the early mornings, when I'm feeding the horses. She's usually on her back deck with coffee, looking out at the pool that cost her more than money. She doesn't wave. Neither do I. But every time I ride past that hedge gap, past the old bridle path my grandfather fought to protect, I think about the easement, about the legal architecture that outlasts noise, outlasts outrage, outlasts people who mistake proximity for power. Katherine Holling learned that the hard way. And the pool she built on land she didn't fully own will remind her every single day for as long as she lives there. Some lessons you don't forget, especially when they're set in concrete.